Ethical clearance is a procedure by which the principal researcher from the establishment has to check that the researcher has filled out all forms correctly, including health and safety forms regarding equipment, the participants, the purpose of the research, and the benefits and risks if the study was going to be conducted. Then this has to be submitted to the Institutional Ethics and Review Committee. This is an overall board that decides whether to approve a researcher's experiment and research. The committee will have knowledge in the field of work you wish to research about. Linking to this, the committee needs to weigh up the risks and benefits from the study before the experiment takes place. This is known as the risk-benefit analysis. The benefits need to outweigh the risks, and then the committee will grant approval of your study. Ethical clearance is split into 4 sections, Part A to D, and each part deals with a different section that the committee need to account for before granting the approval of the experiment. In this scenario, it doesn't state whether the researcher has had ethical clearance, therefore I'm going to presume that they haven't. So the consequences for not having ethical clearance is that the establishment could get fined if someone gets physically or psychologically harmed during the experiment. This could have consequences for the participant if they injure themselves badly and can't work. Even a tribunal can take place. A tribunal is where a person can take legal actions, so it can take it to court where a judge will decide the consequences for the party in question. In this case, prison for the researcher and possibly members of the establishment. This is because nobody from the ethics committee has deemed the experiment to be safe, or even the research to have a purpose, so the establishment and researcher are breaking the law. If the establishment and researcher are prosecuted, then this results in bad publicity and loss of credibility for the establishment. Also, the establishment will be fined and will have to give compensation to the participant, as they have deliberately caused harm to the participant because nobody from the ethics clearance team has deemed the experiment to be safe. For the researcher, this might result in a loss of job and termination of BASIS accreditation. Loss of BASIS accreditation means that future studies that the researcher conducts won't be trusted and people won't view them as reliable. This will make finding work for the researcher much more challenging as they won't be trusted. So the good practice would be having ethical clearance, so making sure that the experiment was safe to conduct before the participants took part. Therefore, this eliminates any legal action being placed upon the researcher and the establishment as the top people, so the ethics committee in this field of work has said the experiment has a purpose and is safe to conduct. So informed consent is where the participants are willing to take part in the research and they understand the protocol of the experiment and they have the knowledge of what is expected of them during the tests. Informed consent also guarantees that the participants have the right to withdraw from the experiment at any moment. In scenario 1, there needs to be a parental consent for them to take part in the study as they are under the age of 18. The children might not have the competence to understand what they are signing up to, so the parents signed it for them to make sure that their child is safe, and then the child knows what to do. In this case, there is consent to go on the trip. However, there is no consent given to take part in the experiment. So this links with deception by commission. This is where the researcher completely and deliberately doesn't tell the participants information about the experiment. This links to informed consent. As if there is no informed consent, then the participants don't know what they are agreeing to and what they are taking part in. On the other hand, deception by omission is where the researcher leaves out information, so tells half of the truth. Deception by omission can't be seen in this scenario, but if it were to be seen, then there needs to be a debriefing after the experiment, or this will have the same consequences to the participant, researcher, and establishment as deception by commission. In this scenario, the children don't understand the experiment and what they need to do, and therefore they feel uncomfortable and reluctant to take part. So the consequences as a result of no informed consent for the participant is that they might experience psychological harm as they feel on edge and not comfortable when taking part in the experiment, causing them to not want to participate in experiments in the future. The consequences for the researcher is dependent on how severe the harm is to the participant. If there is not harm caused to the participant, but the establishment found out that there was no informed consent from the participants that were taking part in the research, then the person conducting the study would probably get a formal reprimand and would be asked to do some ethical training. This is when the researcher gets informed about how to treat participants during the experiment, what they can and can't say, and how to be respectful towards the participants so that they refresh their minds, re-educate themselves about what needs to be done before conducting the research and how to treat the participants so that this situation doesn't happen again. For the establishment, they could get fined if the participants sued them, as the participants weren't told about the full content of the experiment. As informed consent is a legal document, participants need to know the full extent of the experiment so they know what to do and so that they know if they want to take part in it. In this case, the participants didn't know the full extent of the experiment, so felt reluctant, therefore giving them anxiety and psychological harm, meaning that the establishment would have to give the participants compensation for the harm that the researcher has caused. However, informed consent is a legal document, so the establishment and researcher are breaking the law. So another consequence for the researcher will be a tribunal would take place. This is because they are breaking the law, and the researcher might be fined because of this. Because informed consent not only protects the participant, but also protects the researcher and establishment. Good practice for this scenario would be getting the participants to sign the informed consent for the experiment specifically. So this is what the informed consent would look like if the researcher in scenario 1 had given it to the participants. The reason why this is good practice is because the participants then know what is involved in the experiment. They can ask any questions beforehand so that they are comfortable when completing the experiment, and they are confident and don't feel any pressure when doing the experiment, as they know they have the right to withdraw at any time. Also, all participants' results are locked away and no one else sees them as part of the Data Protection Act of 1998. This then eliminates any legal or ethical action being taken against the researcher or establishment because they have provided the legal document and the participants have signed it. Therefore, the researcher and establishment have the permission from the participants, and no participant can say that they don't know what they were doing or didn't know what the experiment was because they signed the document that said they knew everything about the experiment before taking part. Debriefing should take place after the experiment, especially if there has been deception involved. This is where the researcher tells the participant about the results from the tests and making sure that the participants are not physically or psychologically harmed in any way. Even though deception took place in this scenario, there was no debriefing. The researcher didn't check the participant felt well after the test and didn't explain what they were going to do with the results. The consequences of this are that the researcher will get a formal reprimand, so a telling off by a senior member of the staff, because it is courteous and respectful and the participants have the right to know about their results. They will be told to do a debriefing next time so that the participants feel comfortable and at ease. Otherwise, the participants might be psychologically harmed from this because they don't know what's going on, so it might cause them to have anxiety and stress. So good practice in this scenario, with regards to the debriefing, should have been that the researcher should have made sure that the participants felt all right and weren't psychologically harmed from the experiment, and if they had any questions that they answered them, and they should have made sure that all the participants were all right before leaving the area where they conducted the experiment. Also, the participants should have been told about their results, so what they meant in terms of relating it to the experiment. The consequences of this then are that the participants feel comfortable and reassured of any concerns that they had. They don't leave with psychological harm, so they won't fear of participating in studies in the future. And also for the researcher and establishment, this annihilates any action being taken against them, because the researcher has done the right thing and did a debriefing at the end of the experiment, because there was deception in the study in the first place. So anonymity and confidentiality are very important when conducting research as part of the Data Protection Act of 1998. So the Data Protection Act is a law, so the researcher must keep participants' personal details and results safe and secure, and they can't share this information with anyone for any reason. So keeping the data anonymous. In this scenario, it says that the results were displayed on the whiteboard, so all the team could see it. The nature of the results are very personal, and some people could be self-conscious and embarrassed about the results, so therefore causing psychological harm to the participants, because they are amongst their peers, and the nature of the experiment and results are very personal. If someone complained to the participants, complained and took the situation to court, so a tribunal took place, then the researcher would get fined and possibly put in prison. This is because they have broken the Data Protection Act of 1998. So they have broken the law. The law states that the researcher or establishment cannot display any information of the participant that might make them personally identifiable without the participant's permission. All information of the participant should be locked away, protected by a passcode, or locked in a filing cabinet, and not to be shared with anyone. However, if the participant did not take the situation to court, because in this situation they might not know what actions to take place, and just might want to let the researcher be aware of what they've done, so complains to the establishment, then the researcher will get a formal reprimand to be more respectful and take people's feelings into consideration. Or in some cases, establishments can cause termination of the researcher's job, as they have broken a law and they don't want that kind of person representing their company. The consequences for the establishment, if the situation got taken to court, would be that they would get fined. It might cause bad publicity for the establishment because one of their researchers has embarrassed a participant, and they would get fined because they had broken the law and revealed personal information about a participant. As a result of the researcher losing their job, they might obviously find it hard to find another job, due to the fact that they would have a note against them saying that they'd broken the Data Protection Act. So they might find it hard to be trustworthy again. The good practice in this situation would be, firstly, if the researcher had asked the participants' permission to publicly display their information, and for the ones that didn't want their information displayed, so their results, they would have respected that and not shown anyone and kept their results in a safe environment, secured and locked. This would be good because then no participant feels uncomfortable and self-conscious, so no psychological harm comes to the participant, but also the establishment and researcher won't get fined and taken to court because they wouldn't have broken the act, because they would have asked the participants' permission to display that information before displaying the results.